Hello, this is Scott Horton. I will be the presenter for today's webinar. We've now opened the presentation to attendees. So as you are logging in, hopefully you can hear my voice and see the cover slide for today's presentation on FMLA basics and beyond. Welcome as you are joining. Thank you for logging in today. Our webinar will begin momentarily. We're just going to give time for everyone to get logged in as we still have people entering the room. I think it took a couple minutes longer than I was hoping for the room to pop open, but looks like everyone is now able to get in, or at least many of you have been. So hopefully everyone will get logged in here in the next minute or two. In the meantime, you should have access to a chat window where you'll be able to ask questions. And if you have any questions, you can ask them as we go in that chat window. Otherwise, if you can hear me and see the slide FMLA basics and beyond, then you are all set, and we're just going to wait for everyone to get logged in and we will get started. We're a very big crowd today. Looking forward to giving this presentation. Just want to make sure everyone has a chance to get logged in. Okay, so hopefully everyone who is logged in has access to chat where you'll be able to ask questions and can hear me. If you can't hear me, then it doesn't matter what I'm saying, but as long as you can hear me, you should also be able to see the cover slide for the presentation, FMLA basics and beyond. I'm just going to wait about another half a minute or so to let everyone else get on to the webinar, and then we will get started with the presentation. Okay, we're going to go ahead and get started. If anyone else logs in, then hopefully they will do so soon so they don't miss much of the presentation. Today's topic, FMLA basics and beyond, is prompted by the fact that the FMLA will be turning 30 very soon. I will give you the specifics on that in a moment, but just to introduce myself, I'm Scott Horton. I am the owner and founder of Horton Law PLLC, which is based in Orchard Park, New York, just outside of Buffalo. The materials, the slides in particular for this presentation will be provided to those of you who are logged in and registered for the webinar. You will receive an email that has the link to those materials in it. Again, we will have a question and answer at the end. If you have questions, please type them in as you have them. If I happen to see a question and can work the answer in where I'm at, I will do that. Otherwise, usually those get answered at the end of the presentation. We aim for about an hour, but I will stay on to answer as many questions as possible. Just a quick disclaimer that keep in mind, this is not a confidential communication. Even if you are a client of our firm, you would need to speak to me separately about your specific question if you want to maintain confidentiality or privilege of any specific details. And I will say that on this topic in particular, I'm sure many of you have questions. Some of you may have questions very specific to your organization and a situation you're facing in applying the FMLA. I will do my best to answer questions here, but there may be some questions that are just too fact specific to try to tackle. So if you can keep your questions to a little bit more general level, that would be helpful and probably most beneficial to the other attendees. So with that being said, just a quick background on the law itself. This is a federal law that was passed by Congress and then signed by President Clinton back in February of 1993. So a couple of months now away from the 30th anniversary of the FMLA. Which also means that I've been practicing in the field of labor and employment law and working with the FMLA for more than half of its life, which actually starting to make me feel a little old, but I'm, still happy to be practicing in this area and do have a lot of familiarity with the FMLA, including some of the amendments to the statute over the years and some changes to the regulations. As we go further in this presentation, I may refer to the regulations as opposed to the law or the FMLA. The federal government and other levels of government often issue regulations interpreting a statute or an act such as the FMLA. And in this case, the US Department of Labor has issued regulations interpreting the FMLA. And because of the extensive nature of complexities that arise related to the FMLA, the regulations are themselves very detailed and arguably complex. So they are really a critical reference in applying this statute. But fortunately, they do provide a lot of answers. That just also means that there is a lot of detail as well. Generally speaking, the FMLA provides unpaid leave to eligible employees under qualifying circumstances. We will get into what an eligible employee is and a qualifying circumstance in much more detail. The FMLA technically covers all public employers. So if you work with a local government or a state or state agency or even the federal government, then the employer in that government sector is covered by the FMLA. That being said, there are some public employers, localities that are small enough that they would not have any employees eligible to use FMLA. The private sector threshold actually requires that there be 50 employees before the private company is covered by the FMLA. Again, that 50 employee threshold technically doesn't apply to governmental employers. The last point on this slide, that covered employers may not have any covered or eligible employees, means that it ultimately means that you have to have 50 employees anyway before any of them would be eligible. So the fact that a public employer with less than 50 employees is covered by the FMLA doesn't mean that much in practice. It essentially means they have the obligation to at least post a notice of FMLA leave rights under the statute with their other employee right notice postings, whereas a private sector employer with under 50 employees would not have that obligation in the first instance. I think that'll be more clear as we go forward. Just for those companies where this might be a close call, I want to address the counting issues. The question is, did the employer have 50 or more employees in the United States on its payroll during at least 20 weeks in either the current or preceding calendar year? If you are close, then that's generally speaking the test that you would apply. It does not mean that you have to currently have 50 employees, or that if you have 50 employees when someone goes out on FMLA leave and then you drop below 50 employees, that the employee would then lose the right to be on FMLA leave. So very important to note that it could be triggered based on how many employees you had the first 20 weeks of last year, for example. And you do count all full-time, part-time, and employees, even who may be on leave and not currently working or receiving compensation. The regulations specifically say if the employee is on the payroll, they count. Further says that if there is someone who is on leave, then the standard is whether they have a reasonable expectation of being restored to their job. That could mean they're on FMLA leave, for example, or it could mean that they are suspended for disciplinary reasons or any other form of leave that the company is allowing and nonetheless expects the employee to return to work. Frankly, one would say if you're not expecting the employee to return to work, then maybe they don't need to be on the payroll in the first place. But regardless, if you haven't taken them off, you do risk them counting for FMLA coverage. Just a couple more points that will apply in some cases and can really be important to the employers that it does apply to. For joint employers, this would mean, for example, workforces that have temporary agency employees on site working with them, or companies that, for whatever reason, share an employer or employee, which happens in various ways. The FMLA is clear that those employees count towards both employers' coverage thresholds. So if someone works for the staffing company and is on your work site performing manufacturing functions for your company, then they count both toward whether the staffing company has 50 employees and whether you have 50 employees. But the law and regulations do assign responsibility for administering the FMLA to the primary employer, where the primary employer may not always be easy to determine. Typically in the Typically in the staffing agency scenario, the primary employer is going to be, for this purpose, the staffing agency, because they're usually the one paying the employee and providing benefits, if any. But it is a case by case determination, and I listed the primary factors here for your consideration if that applies to you. The other consideration that may be more important for some companies is this notion of an integrated employer. The bottom line is that separate legal entities can be deemed a single employer for FMLA purposes. This could have various implications, but as an initial threshold matter, for example, if some management group has two separate legal entities, and even if they have two separate payrolls for those respective entities that each have 30 employees, it is possible that both of those legal entities would be deemed to be covered by the FMLA if they share sufficient interrelation in their operations, where a big factor tends to be this notion of centralized control of labor relations. In other words, if you have one set of employee rules or policies that apply for both legal entities, or especially if you have the same people managing both entities and setting the rates of compensation and doing the hiring and firing, then the mere fact that you have two separate payrolls and two separate legal entities would not necessarily protect you from coverage under the FMLA. So again, that's not going to be every corporation or other business entity, but it does affect some, and it could determine whether you're covered by the FMLA in the first place. It could also impact employee eligibility, which we now turn to. So there are three main requirements to have an employee be deemed eligible for FMLA leave. Now, here we're using the term eligible specifically, and this doesn't mean that the employee necessarily has uh, the right to take FMLA leave at a particular point in time. It just means that they would be eligible if they otherwise or find themselves in a situation that would allow someone to take FMLA leave. Specifically, you have to be employed for at least 12 months with the employer. You must have worked at least 1,250 hours in the past 12 months and work at a work site where the employer employs at least 50 employees within 75 miles. So this 50 employees within 75 miles goes back to the issue I was alluding to before, that if you, for example, a government employer and don't have 50 employees, you're covered, but none of your employees would be eligible because you don't have 50 employees within a 75-mile radius. Conversely, an employer with 1,000 employees in the United States theoretically might not have any eligible employees because those employees are so spread out that there are never 50 or more within any 75-mile radius. I think that that is an unlikely scenario, and I haven't actually done the math on a map of the United States to determine whether it's even possible. But more common scenarios would be a company that has, say, two offices and they're separated by some distance, and neither office has enough employees to trigger the 50 employee within 75-mile threshold. The employees are not eligible, but nonetheless, because the employer overall has 50 employees, they are covered by the FMLA, meaning they at least again have to satisfy the general notice requirements, which I will address in more detail. Okay, the 12-month employment issue is another one that can be overlooked or misapplied in some situations. First of all, it is important to note that the 12 months of employment and the 1,250 hours in the past 12 months are determined based on when the leave would be scheduled to begin, not when it's requested. So if someone says, I need to take time off that might qualify under the FMLA beginning the first of the year, and they have not yet met the 12-month requirement, but will by the first of the year, then they are an eligible employee with respect to that leave. If the employee is on the payroll for any part of a week, that week counts as a week of employment. So the first day that an employee is hired, if that is in the middle of a week, that week nonetheless counts. Again, remember, we're talking about on the payroll, so it doesn't matter whether they even get paid for a particular week or whether they're on paid or unpaid leave. But if they have been employed, considered to be on the payroll for any part of the week, it counts. And this 12-month requirement does not have to be met consecutively. So, for example, seasonal employees can accumulate 12 months over time. They may or may not then be able to meet the 1,250 hours in the past 12 months requirement, but there's two separate prongs to this eligibility. So any combination of 52 weeks on the payroll for that employer equals 12 months and meets this requirement. Again, separate and apart from whether the 1,250-hour requirement has been satisfied at any given point in time. The regulations do say that if the employee has separated for more than 7 years, then comes back to work for the same employer, then that gap is sufficient to cut off the accumulation of weeks of employment for FMLA eligibility. That's a relatively uncommon scenario, but that is addressed in the regulations. And again, as we go, there is no way I can address every item of compliance under the FMLA or everything that is addressed in the regulations in this webinar, but the goal is to, in providing an overview of the basics, identify how some of the topics that on paper seem kind of routine can in practice actually be misconstrued or misapplied or misinterpreted on one side or the other, either from the employee's perspective or from management's. So again, even if you've worked for 12 months, you have to meet this 1,250-hour requirement. Here, this is measured backwards in a consecutive 12-month period. So this is not cumulative during employment. This is, have you worked enough recently to now be eligible to take time off from work? Only hours actually worked satisfy this 1,250-hour requirement. So time taken either on previous forms of FMLA leave or for vacation or sick leave that the company allows, what have you, those do not meet the 1,250-hour requirement. This is a requirement that says not just how long have you been working for the company, but have you, in essence, contributed enough in the past year of actual work to the company that the company should now be expected to let you take time off. Certainly, if someone just was perpetually on FMLA leave, it could make it difficult eventually to maintain this 1,250-hour requirement. So this can result in individuals not being able to take FMLA as much as the law theoretically allows, which by default in most cases, as we'll get to, is 12 weeks per year. But depending on how many hours you regularly work, if you were to miss some or all of that 12 weeks for FMLA leave in 1 year, then you may not be able to take FMLA in the next year, at least depending on how that next year is defined, which again, we will get back to. The main caveat on this is this ideally should be pretty easy to track for hourly employees who have to record their time, and that determines their compensation, where ideally your payroll system is separating out hours worked from other hours. The regulations from the Department of Labor emphasize that if there's not an accurate record keeping of hours actually worked for an individual employee, then the employer basically would have to prove that they hadn't worked the 1,250 hours in the past year to be able to deny FMLA leave on that basis. So where this is most likely to come into play is for exempt employees. Exempt and non-exempt employees with respect to minimum wage and overtime are equally eligible for the FMLA. The only exception to eligibility is for key employees, which we will address briefly later in this webinar. But for an exempt employee, many companies will just assume they're working 40 hours in a week. But technically, if that math doesn't get them to 1,250 hours and they can argue that they actually work 60 hours in a week, for example, such that they did have 1,250 hours, then it would, again, be the employer's burden to somehow prove out the math that the number is not met. There are some companies that go to the step of tracking time worked for exempt employees, in part because of this FMLA requirement. That is not an obligation under the FMLA. The FMLA itself does not require you to track anyone's hours. But again, if you can't prove that they worked less than 1,250 hours, it would be at your risk to not allow the FMLA leave. Okay, so we've covered the eligibility and coverage issues generally. Now we get into sort of the real meat of what FMLA leave is. So while the eligibility conditions are one consideration, the next factor once someone is eligible is whether they have a qualifying reason to take FMLA leave. Most of these are well known to most of you, probably, and to most people in the United States at this point who have been in the workforce, I would say, or at least who've worked for companies large enough to be subject to the FMLA. But there are plenty of details that can create complications in specific situations. But generally speaking, the birth or to care for a newborn child or placement of a child for adoption or foster care are pretty well known to be covered reasons for taking FMLA leave. Most of the other scenarios relate to someone's medical situation. So, an employee can take FMLA leave to care for the employee's spouse, child, or parent with a serious health condition, or in the case that a serious health condition makes the employee um, personally unable to perform the functions of their job. There are two other categories that qualify for this leave that are newer. They have not been around since 1993. They relate to military service in different ways. One form is this qualifying exigency leave, and that's just the term used in the law, a qualifying exigency arising from the employee's spouse, child, or parent serving as a military member on covered active duty or call to active duty status. We'll briefly go over what that actually might mean. And the other form of leave is for the employee caring for a covered military service member who is their spouse, child, parent, or to whom they are the next of kin with a serious injury or illness. I'll note right now, and I'll reiterate it in just a couple of minutes, that there are two different medical condition terms in play under the FMLA. One is the serious health condition, and this is for the traditional forms of leave that don't necessarily have anything to do with military service. And then the separate form of leave for this service member, military caregiver, as it's also referred to, leave, where the term serious injury or illness has been added. They are defined differently, and my main note on that at this point is just if, for example, you're applying the FMLA and you get to looking up some of the details of this somewhere, whether it be in the regulations or where have you, be careful that you don't accidentally apply the serious injury or illness standards when you should be applying the serious health condition standards or vice versa. It's not necessarily super easy to do, but there is the risk of confusion. So, what is a serious health condition? Again, this is the category that goes back to 1993 and really is the basis for the medical component of the Family and Medical Leave Act. So, a serious health condition is an illness, injury, impairment, or physical or mental condition that either involves inpatient care, so hospitalization most notably, or continuing treatment by a healthcare provider. Inpatient care is explained in the regulations in more detail, but is generally somewhat self evident. The continuing treatment by a healthcare provider is more complex in most situations. And that is what you're usually trying to analyze um, when you're receiving a medical related FMLA request. Continuing treatment can be any of these categories: incapacity and treatment, which is defined in a particular way, which I will get to, pregnancy or prenatal care, which is pretty self-evident, chronic conditions, where chronic conditions would be something for which there may not even be an effective form of treatment. So, while it's technically a category, a subset of continuing treatment, the treatment is likely no more than, in some extreme cases, checking in with your medical provider, perhaps even hoping that there's some new treatment where nothing else has either previously worked or even been able to be attempted. There's permanent or long-term conditions. Again, this is technically distinguishable from chronic conditions because um, you know whether there's treatment available or what have you. But again, these are not that hard to understand when they exist. And then there's conditions requiring multiple treatments. Again, the regulations describe all of these, but the one that can be complicated and can raise real coverage questions is the incapacity and treatment category. And many of you who have faced administering the FMLA will recognize this requirement that the incapacity last more than 3 days. So this is really designed to distinguish just occasional sickness, like having a cold, from a more serious impairment or illness. So if you don't fall into one of those other categories, which if you did, you would probably suffer from it for more than 3 days, probably consecutively, but not necessarily. And it may not always be incapacitating. What's the easiest example of this? For example, if you have migraine headaches, migraines typically don't last 3 consecutive days, but they would nonetheless qualify under one or more of these other conditions. But if you, for example, have the flu or a certain virus that we've all become familiar with in the past couple of years, unfortunately, you may have a threshold question of whether your incapacity lasted more than 3 days consecutively. If so, you have to do more than sit at home to be able to take FMLA leave. You have to have that incapacity plus some sort of treatment, and that has to either be treated at least 2 times by a healthcare provider for that condition within 30 days of the first incapacity. So again, if you have a cold, you might go to the doctor, or if you have a sore throat, you might go to the doctor, and it may end up keeping you ill for more than 3 days, but there would generally have to be some form of follow-up. If there's a follow-up appointment within 30 days, then this first prong would apply. If not, the question becomes whether the treatment by the healthcare provider resulted in a regimen of continuing treatment that is supervised by a healthcare provider. If there's some sort of prescription medication prescribed for the condition, then that may qualify as a regimen of continuing treatment. Not the only form, perhaps exercise or some form of physical therapy may also qualify, but it can't be just going and purchasing an over the counter medication after you've met with a doctor and said, you're okay, just take some aspirin. Okay, so moving off of those medical issues, the family portion of the leave historically covered the birth of a child, adoption, or foster placement, um, I suppose now includes these qualifying exigency leaves as well, because these are not necessarily military. So these conditions would have to relate to someone being um, inactive military duty or called to active military duty. And this list is provided now in the regulations, but there's also a catch-all that says anything else that essentially qualifies. A little more detail on that, but the idea being that if someone is going off to military duty and is going most likely to be leaving the area or not be available any longer, then the close family member, parent, spouse, or child can take time off of work under protected under the FMLA for these various types of situations that don't necessarily have anything to do with a medical condition or there being a new child. Military events and related activities, for example, if there was some sort of send off ceremony or even return from duty ceremony, that would likely qualify. Childcare and school activities would include time spent either caring for a child that maybe hypothetically was previously performed by the person who's now off to military duty. It could also include time spent arranging new coverage for child coverage, financial, legal arrangements, counseling, even rest and recuperation. So this would include someone who has been on military leave and or maybe returning to military leave and wants to spend time with their family to rest up or recuperate from that leave. So a pretty wide array, but again, it would have to connect to some sort of active military duty in some way. Again, there's more detail in the regulations on this, but rather than give a whole presentation just on qualifying exigency leave, I just refer you to look into that further if by chance you have been around before qualifying exigency came in to the FMLA and hadn't dealt with any of these situations yet, because they're not super common in many workplaces, but when they do arise, now you know what you're looking for. The other new, comparatively new, although I don't know, probably a decade or so old by now, military form of leave under the FMLA relates to serious illness or injury of a covered service member. These can include both active duty and retired or veteran military members. So in the case of an active member of the military or someone who would otherwise be active, the qualifying condition had to have occurred in the line of duty, on active duty in the armed forces, or was aggravated by service in the line of duty. So it could be a pre-existing condition that where there's a determination that active military duty aggravated the condition, and it has to render the member medically unfit to perform the duties of the member's office grade, rank, or rating. That doesn't have to be a permanent inability to perform the duties, but even a temporary inability. And in these cases, again, the employee is not the military service member, but their family member is the military service member. Then they get to take time off if they want under the FMLA to assist that individual. While I noted the definitions are different, it's certainly plausible that what would qualify as a serious injury or illness for a military service member could also qualify as a serious health condition under the traditional medical leave component. And the same individual, the spouse of your employee, for example, might be this the coverage might be otherwise the same under the traditional FMLA standards versus the military leave standard, but there is a critical difference as to which category of FMLA leave the employee is taking, which I will get back to in just a moment. Quickly, for completeness, the serious injury or illness for a veteran just effectively acknowledges some lasting or lingering military related injuries and illnesses. So those are listed here. The VASDR is the Veteran Affairs. I don't remember all of it, but it's a disability rating. So that could be a permanent impairment. The reason these military leaves can be distinguishable, even though they might also qualify as serious health conditions, is that the military caregiver leave, not the qualifying exigency leave, has a special leave allowance. So, for all of the traditional forms of FMLA leave, birth of a child, or the serious health condition of a family member or the employee, um, personally, the leave allowed is 12 weeks per year. The military caregiver leave, for whatever reason, has a special leave period allowing 26 weeks in a single 12-month period. This means that if the requirements are met for that form of leave, then the employee could take 26 weeks off within the next 26 months, whether that be consecutive or intermittently as appropriate, which obviously is longer than the 12 weeks allowed for all other conditions. It, on the other hand, is limited to a single 12-month period where the other leaves are 12 weeks that could reoccur as often as every year, where we still have to talk about what the year is. You could have more than one 12-week military service member leave, either for multiple family members who have injuries from military service or from the same family member who had separate injuries or illnesses arising from military duty. So that is important to note. It's also important to note that in any period where your employee is taking 26 weeks or any leave for this military service member special category, that is not in addition to 12 weeks that they're allowed for other forms of leave. They're still not allowed any more than 12 weeks in that 12-month period for those other forms of leaves. But if they did happen to, say, have a child and take 12 weeks for that and then want to take the service member leave, they would then only have 14 more weeks. So it can't be more than the 26 weeks, and it can't be more than the 12 weeks for the other qualifying conditions. Now, we do need to get back to this year question. So for some, there are multiple years at play under the FMLA. For the purpose of counting your employees, it's calendar years. The current or previous calendar year determines employer coverage. We talked about the years related to employee eligibility. The 12 weeks per year raises another question. You can use any of the types of years defined on this slide, but you can't change your year to try to avoid having people be eligible to take FMLA leave. So again, this doesn't technically affect whether they've been employed for a year or whether they've worked for more than 1,250 hours in the past year, or whether you've had 50 or more employees for 20 weeks in a year, but it does apply for whether they have used up their 12 weeks in the current year. So you could use the calendar year. Every January 1st, everybody has a new 12 weeks of FMLA available if they're otherwise eligible at the point that they want to take the leave. That, in my experience, is not a common practice. It's an easy enough one administratively. The problem is it would present a scenario where employees would relatively frequently be able to take off up to 24 consecutive weeks because they could take off the last 12 weeks of one year and the first 12 weeks of the next year, which is generally not an ideal scenario that employers want to permit if they don't have to. You can also use any fixed 12-month period, such as a fiscal year, so essentially the same circumstance as the calendar year, it just might correspond with some other fiscal year that your organization uses for accounting purposes. Or you could use a leave year that begins, for example, on the employee's first day of employment or the first day of the month that their employment started, what have you. Again, neither of these are particularly common for basically the same reason I just mentioned. The other forms of years that the statute and regulations permit are rolling 12-month periods. One way of doing it is saying, okay, the first time someone takes FMLA leave, we will start the clock. They will have 12 weeks to use in the next 12 months. At the end of that 12-month period, before the end of that 12-month period, if they hit 12 weeks of leave, then they are done and cannot use leave again until the end of that 12-month period. If they then don't use leave for some period of time after that, the clock hasn't started yet. It will start again the next time they take leave. That is, again, not what most employers choose to do, because the alternative, the next method, tends to reduce the overall amount of leave that employees would take. That is a backward rolling method from the date an employee uses FMLA leave. So every essentially day someone is out on FMLA, or even portion of a day, the question then becomes, in the past 12 months, have they used 12 weeks of leave? If not, they can use the leave. If so, then they can no longer use it. So this really has the effect of minimizing the total amount of time over the course of employment that employees on average would be able to use under the FMLA. Whether you agree with that philosophy or not, that is the prevailing practice in most workplaces. It does have both administrative pros and cons. It's a little bit more complicated because you can't really tell exactly when someone's FMLA leave is going to run out, especially if they're taking it intermittently. But again, it does reduce the amount of time that employees should be off of work under the FMLA. Okay, the next topic I want to get to is the employer notices. This is another one that could lead to significant problems if you don't document everything properly. So I mentioned before, if you're covered by the FMLA, you have to post the employer rights notice. So you have these on bulletin boards or where have you in your workplace. There is one from the Department of Labor on the Family and Medical Leave Act. Post that. the law and regulation, or the regulations now require distribution of certain rights information, which would be met by posting, or by providing that notice to employees personally, either through an employee handbook or policy manual, or if you don't have one of those, needs to be given to new hires. Again, this is for covered employers. If you don't currently have under 50, if you currently have under 50 employers, based on that counting method we talked about earlier, you don't have to provide, you don't have to post that poster or provide the notice unless you are a government employer, in which case you have to do it, even though you may want to, in handing the policy or the notice to someone, note to them that because you don't have 50 employees, they're not actually going to be able to take that leave. And then the next question becomes, okay, now somebody wants to go out on FMLA. The employer is then obligated to provide a written notice of eligibility and rights and responsibilities within 5 days from the employee giving notice of the need to take leave. I think this doesn't happen in all organizations, and not maliciously, but just because people say, okay, I'm going to have a baby, and they say, all right, you're fine, you get your 12 weeks, you may have other leave protections anyway, and then it gets recorded, and eventually your 12 weeks are up. The problem is the FMLA does require that written notice of eligibility, rights, and responsibilities be given beyond just allowing someone to take the leave. In many cases, that might not be more than a technical violation, but if you get into a scenario down the road where somebody can test how much leave they should have available still under the FMLA, having not provided that notice could be a problem. Similarly, there's this designation notice that would also be provided to the employee to say, okay, you are approved to take this FMLA leave. Again, this has to be in writing. The Department of Labor has forms for all of this. You don't have to use their forms. You just have to provide the information. But the easiest thing for most employers is just to use the Department of Labor's forms. The designation notice can be given with the eligibility, rights, responsibilities, paperwork. And the reason it sometimes isn't is because once you get the request, you should give out that eligibility and rights notice, and you may, in connection with that, be asking the employee to provide a certification, either of the medical issues or the military service eligibility, for example. And you can wait till you get that back before designating the leave as FMLA leave. So that designation leave notice sometimes is a separate event. What does the employee have to do on their end of it? There are no magic words to request leave, but there are cases that say it's more than calling in sick. Again, saying I'm sick doesn't give any clear indication that you're going to be out for more than 3 days and have a continuing treatment of a healthcare provider. So there's something more than that, but you do not want to deny someone FMLA leave because they didn't specifically say, I want to take FMLA leave or leave under the Family and Medical Leave Act or my federal family leave. You know, none of those things have to be said. It's just a question of, has the employee said enough to put the employer on notice that their time off may qualify for FMLA leave. Employee is supposed to give at least 30 days advance notice if the leave is foreseeable. If the leave was not foreseeable, they're supposed to give as much notice as practicable. I don't run into too many issues where employers are questioning whether the leave was foreseeable or not, and then whether they've given sufficient notice. I mean, for the most part, the employee by this point is going to be off one way or the other, and employers would rather just count the leave towards the FMLA allowance rather than leaving it on the books to use later. This brings in my first opportunity to point out that the FMLA, of course, has complex interactions with various other laws. At the national level, there's the Americans with Disabilities Act, which requires reasonable accommodations, which in some cases can include leave. So there are scenarios where someone is on FMLA leave, and that leave may also be something that qualifies as a reasonable accommodation under the ADA or a state disability employment protection law. So, there's usually not as much motivation to say this doesn't qualify for the FMLA anymore because you didn't give enough notice, in which case, it may be that the employee would have a right to a short term, for example, leave from work anyway under the ADA. So, probably better to have it run their FMLA leave. If the employee is asked to provide a certification, then they are expected to do so within 15 days. The employer is supposed to tell the employee when they give them this certification what the consequence is for not returning the certification. If you use the Department of Labor forms, then that is something that can be addressed based on the language in those forms. Here's another subject where we could have probably a whole day seminar addressing intermittent leave. There's intermittent leave, and then there's reduced schedule leave. But either way, it's the idea where someone is still going to work some of the time, and then they're going to have to be off occasionally, or whether that's scheduled or indeterminate as needed. This type of leave is available under the FMLA. The law allows employees to take leave on an intermittent or reduced schedule basis when it's medically necessary or for those military-related qualifying exigencies. In other cases, which essentially means the birth or placement of a child, the law does not require employers to let employees take that leave intermittently, but they may allow employees to take that leave intermittently with the agreement of the employer and the employee. Obviously, a caveat there is be careful if you pick and choose who you let take leave intermittently for birth of a child. That could lead to some other discrimination claims, and there may be other state laws governing parental leave that could have implications here. Under New York's paid family leave law, the leave for birth or placement of a child can be used intermittently by law. So if your FMLA leave is running concurrent with paid family leave in New York, for example, then the employer can't deny the intermittent use. They would just usually want to count that toward the FMLA as well as the New York paid leave. And other states have similar requirements, but that was just an example. What I mentioned up front and have just mentioned now is that the FMLA itself, as of today in 2022 and since 1993, is an unpaid leave statute. So it does entitle employees to time off from work. And as we're going to wrap up with in a minute, it does entitle them usually to be restored to work after they're done with their leave. It does not give them the right to be paid during the time off. However, if the employee has other paid time off available, the employee may choose to use it, sick leave or paid time off, that can be used in whatever the circumstances are that the employee is using FMLA leave for, can be run concurrently, and the employer may require that they run concurrently. And this would go both ways. If someone says, I want to use my time, but I don't want to use FMLA, the employer could say, okay, but it qualifies for FMLA. Here's the paperwork. We're going to count it anyway. It's not the employee's option whether to use FMLA, if the leave qualifies. But there's a big caveat here, and that is that the employer can only require the employee to use another form of paid leave concurrently if the FMLA leave is unpaid. So if someone is on leave that qualifies as FMLA leave, and they're also receiving some form of paid leave, such as statutory paid family leave or disability or workers' compensation leave, then the employer can no longer require the employee to use another form of paid leave, such as sick leave or the company's PTO bank. So the last two big components here are that, yes, you have to allow employees to take this time off if they're eligible and qualify. While they're off, employers have to maintain their eligibility for health insurance benefits. Obviously, many people on FMLA leave are in situations where health benefits are important. So that was specifically included in the law. The employer must continue to make premiums, assuming it was making premiums when the employee was not on leave. But likewise, the employee is expected to make whatever contributions toward the premiums they normally make. If the employee is not receiving pay during the leave, then the ability of the employer to deduct the contributions from the paycheck dissipates or disappears entirely. So there would have to be alternative arrangements made. Those arrangements can include having the employee agree that they will pay the money back once they return to work, and that can be done through payroll deductions in most cases, potentially subject to guidelines and potentially different state laws that might limit how and how much money can be taken out of an employee's pay. But generally, health insurance is something that can be deducted from pay, and therefore, the fact that the employer basically fronted the money for the health insurance in most cases means that they can recoup it. Of course, that depends on the employee actually coming back to work. The problem that some employers run into is an employee says, well, I can't afford my health insurance when I'm not working, especially if I'm on unpaid leave, and I'm just going to drop the coverage. That's fine. The employee is not going to pay for it, then the employer can certainly drop it. But as soon as the employee comes back to work, they're then entitled to have the coverage reinstated immediately without any waiting period or um, exceptions for pre-existing conditions, etc. So I've had experiences where companies found that they couldn't essentially drop the coverage for 12 weeks or less and then reinstate it seamlessly as they would otherwise be required to by the law. So sometimes companies have just left the coverage in place, which is a case by case situation whether that's a good idea, but I have seen that happen. So finally, employees go out on this leave and then they get to come back to work, right? That's the whole point of having the leave, is that it's job protected. You're not getting paid, but you get to take the time off and know that your job is waiting for you. Employees retain all benefits and seniority that were accrued before they took the leave, but the statute itself doesn't require that they accrue additional seniority or benefits during the leave period. Doesn't say they can't, it just says they don't have to. If you have other obligations under employment contracts or collective bargaining agreements, that could control in that area. But what they do have the right to do under the FMLA are be restored to the same position they held when they took the leave, or to an equivalent position with equivalent pay, benefits, and other terms and conditions of employment. In most cases, this is not a problem. The full understanding is someone's going to go out for up to their 12 weeks, or in the military service member scenario, up to 26 weeks, and then they're going to return to their same job. But there is an allowance that if you need to make some change to cover the work during the time, or you otherwise change the structure of your workforce, you could return the person to an equivalent position with equivalent pay in terms of employment. Obviously, the regulations go into more detail on that you could dig into if need be. Finally, before the questions, if you have questions, make sure you're typing them in now. We have a couple, and I will start answering those as soon as we get through this last point. There are exceptions to the reinstatement requirement. First of all, the one that's kind of fun in theory, but not so much of an issue in practice, is the key employee exception. So if you have someone who qualifies as a key employee within your company, then you can give them notice that they won't be reinstated from their leave. First of all, the person would have to qualify. They have to be a salaried employee, and they have to be among the highest paid 10% of your employees within a 75-mile radius. Okay, assuming someone qualifies, you still have to reinstate them unless you can make the determination that reinstating them would cause substantial and grievous economic injury. Doesn't mean letting them go out of work on leave would cause that injury, which might actually be an easier thing to prove. You'd have to show that reinstating them would cause a substantial and grievous economic injury. And the most likely scenario where that would happen is that if they're going to be out for this period of time, up to 12 or potentially even 26 weeks, then we're going to have to replace this person because they're so critical to the organization. And if we do that, then we're going to have to hire somebody permanent, or else we won't be able to get the person we need. And then having to suddenly remove that person to reinstate Mr. Key Employee or Miss Key Employee or what have you, that would cause substantial and grievous economic injury. Reality is this really doesn't come up too much, because most of the time, if you have a key employee who takes FMLA leave, you probably want them back. But it is an exception that can be used where warranted. And finally, the FMLA does not give someone any greater protections in their job than they would have had if they just continued working and didn't take the leave in the first place. In other words, you can still fire people who are on FMLA leave. You can fire people after they return from FMLA leave. They may not like it, and they may claim that it's in violation of their rights because they took the leave. And that could be a good claim in some situations. The question is, what is your reason for firing them? It is not unheard of for companies to discover when someone is out on leave that they've done some really bad things once they're not performing that job on a day-to-day basis, and then you need to terminate them for doing it, for example. So when I say you can fire them, I mean that the law would allow it, subject to, the challenge that wasn't the actual reason. And you can otherwise change jobs as well. So if you conduct a layoff for economic reasons and eliminate positions, and that includes positions that had people on FMLA leave, again, you can do that. You could change job titles, you could reduce pay or compensation. Any of those things, the question just becomes, did you do it because the person was on FMLA leave, or did you do it for some other unprotected reason? Final point is, what happens when someone doesn't return in 12 weeks? Can you summarily fire them? Usually the answer is that's probably not a good idea because, as I mentioned, they may have some protection under some other law. For example, the ADA, if they can't return from a medical condition after 12 weeks, but would be able to after 13 weeks, trying to fire them in that intervening week certainly risks a disability discrimination claim, and potentially in any circumstance also risk claims of violating the FMLA, which also prohibits retaliation against employees for using the law. Ask that you follow us if you want to get our most recent updates on LinkedIn. It's where we post information as soon as we can about changes in labor and employment law. And at this point, I will turn to questions. All right, so one question I have says, a staffing agency has an employee in a particular state, one employee in a particular state, but the client, so the staffing agency's client, which may be a joint employer of this employee for FMLA purposes, the client has more than 50 employees. Is the employee entitled to FMLA leave? So if the employee qualifies as a joint employee, or if the employee qualifies as an employee of both the staffing agency and your client where they're working on site, and that client company has more than 50 employees, then yes, the employee is going to be eligible to potentially take FMLA leave, obviously subject to the other requirements of having worked then for that company for more than a year and for more than 1,250 hours, and then having a qualifying circumstance. In that situation, I'd have to probably actually dig a little bit more into the regulations, but it could be that while you might otherwise be considered the primary employer, if you didn't have 50 employees within 75 miles of that employee, then it gets a little more complicated. But yes, I think ultimately that employee is going to have the rights under the FMLA, and then it becomes a complicated question as to which company owes that person the protections. If, on the other hand, the arrangement was such that you could justify treating that person as an independent contractor of the staffing agency, then they wouldn't be an employee. An independent contractor of your client, then the employee wouldn't work within 50 miles, 75 miles of 50 or more employees of the staffing agency, and they're not an employee of the placement client, then they would not have leave protection. So that is a very good question. It's a very complicated one, but there is certainly, in the average situation, a good risk that person would be considered an employee of both companies, and then in that scenario, subject to the FMLA. Here's a question. What is the recommended deadline for the employee to bring in the supporting documentation for the FMLA request? They're supposed to provide it within 15 days, assuming they've been told to provide it within 15 days. That's what the regulations permit. So you generally couldn't have a shorter period. You could have a longer period. And again, the regulations basically say, you have to clarify to them what the expectation is, whether it's 15 days or something longer, and you have to warn them what the consequence of not doing it is. So theoretically, in most cases, you could say bring this certification in within 15 days, or else you're going to be denied the leave. Of course, especially if there was an unforeseeable leave, the person could already be out of work, so that raises the complication. But two notes on that: you probably aren't firing the person for not returning the paperwork. You may just then not count that as FMLA leave. And if they have, in fact, been out of work, it might then be unprotected leave, which could potentially lead to a basis for discipline. But be careful what you do there and think it through. The other caveat on this is there is language in the regulation that talks about, well, what if it's not possible for the employee to return the certification within 15 days? I think what you do see a lot of times is employees say, well, I couldn't get into my doctor, or they wouldn't get the paperwork back, or whatever. I think most employers try to be somewhat flexible in that. But if you really have a specific situation, I think you need to review the regulations and be careful. But there's a lot of, to be real practical about it, I think there's a lot of incentive to be cautious and allow a little bit of leeway in those situations, including because there are other laws that may protect the employee anyway, such as the ADA or a state law, where, okay, the question, almost an academic question sometimes, whether the FMLA applies, because the person's going to be out of work anyway. So employers are often better off trying to count it as FMLA, and thus they'll allow some more time to get the paperwork. Are remote employees eligible for FMLA? This is a very good question. Obviously, the framework has potentially changed under COVID. Historically, the concept was that the remote employee's job site was where they reported to, from, out of, however you want to call it. So an employee who worked at home, but reported into and out of your home office, wherever that was located, was deemed to be working in that office wherever it was located. And so the question was, were there 50 or more employees within a 75-mile radius of that office? But as we have now seen, there are many more employees who might never almost step foot in any physical premise owned or controlled by their employer. So that does raise the question of, do we calculate the 75 miles from their house in that situation? It also raises the question of, well, what if the person never actually works at their house, but always works from the coffee shop 15 minutes down the road? And then does that change the calculation? So, there are potentially new circumstances that are kind of emerging since the regulations were last updated. So it is possible that courts would start to interpret that statutory language different, but the regulations, here's the punchline to all of that disclaimer language, the regulations do suggest that the employee's worksite is the primary office from which they are assigned or report. So again, the reason I hedged all of that is we know what the regulations currently say, but the regulations are pre-COVID. The regulations are not as um, infallible as the statute itself. So, you're good under the regulations to count the location to which they report or work out of. If you can determine which that one is, and sometimes that's not an easy call. But we probably will see claims when it's somehow beneficial to the employee that their remote location is their work site. Usually, however, the reporting office is going to increase the likelihood that they're covered by the FMLA. And I think I would say that given the regulations as they exist now, you want to err on the side then of considering the person eligible. I think I have one more question in queue. If anyone else has one, type it in or start typing it in, or at least say, hold on before I wrap up. But I will try to address this question that says employees are entitled to return to the same position, but not required. There might be a word missing, but if not, just to try to clarify that. So the entitlement is generally to be reinstated to the same position or an equivalent position with equivalent pay and benefits. Obviously, determining what an equivalent position is can be complicated. Usually, equivalent pay and benefits is not too complicated. Um, So, from that standpoint, again, it doesn't have to be the exact same position, and you don't have to justify, changing to an equivalent position. You just have to justify that it is an equivalent position. And then, as I went through before, all of that is subject to, but that doesn't mean you have to return them to any position if you have some other reason to end their employment that isn't because they took FMLA leave. I did see one more question so far. Again, if you have any more, I will stay to answer them. But as of now, the last question says, does FMLA and workers' comp run concurrently? This goes back to the question of other paid leaves and substitution of leaves that we talked about. I don't think I mentioned workers' comp specifically, but again, the idea would apply uh, as long as there's not something specific in your state's workers' comp law that says otherwise. So, workers' comp is a state by state law issue, and there may be some states that have some nuance to it, but barring something like that, the FMLA itself would allow the employer to run it concurrently with workers' comp. They just wouldn't then allow the employer to require the employee to use some other paid leave benefit top of the worker PTO or anything like that, because at the point in time that the leaving workers they're on FMLA, it's then, even though the workers' comp isn't necessarily